In my 40 years on the bench, I've learned something that no law school ever teaches you, and that's how to read a person, not their file, not their charges, the person, the way they hold themselves when they walk through that door, the way their eyes move when they answer a question, the small hesitations, the practiced sighs, the carefully rehearsed stories about hardship and struggle. I've sat across from thousands of people who were genuinely down on their luck, single mothers working 2 jobs, elderly men living on fixed incomes, young people who made one mistake and were desperately trying to climb back. I know what real struggle looks like. I've seen it my whole life, growing up in Providence, watching families fight for every dollar they had. And because I know what genuine hardship looks like, I also know within about 30 seconds when someone is using hardship as a costume. This case was one of those moments. A young man came into my courtroom with a story so carefully constructed, so full of the right details in all the right places, that most people might have believed every word. But something told me to look closer, and what I found underneath that story, that's what I want to tell you about today. When this case landed on my desk, it didn't look particularly unusual at first glance. The charge was a series of unpaid parking violations, 8 of them, totaling $640 in fines accumulated over about 14 months. The defendant was a 34-year-old man named Daniel Mercer. According to his file, he'd requested a hearing specifically to address the fines, and his request form indicated financial hardship as the basis for seeking a reduction or dismissal. Now, I want to be clear about something. Financial hardship is a legitimate and important consideration in my courtroom. The law isn't meant to crush people who are already struggling. If someone genuinely cannot pay, I want to know that. I've reduced fines, set up payment plans, dismissed penalties, because justice isn't about extracting every last dollar from people who don't have it. That's not justice. That's cruelty. But here's the other side of that coin. When financial hardship becomes a tool, when it becomes a story someone deploys to avoid accountability, that's a problem. Because every time someone games the system with a fabricated sob story, it makes it harder for the people with real struggles to be believed. As I reviewed Daniel's file before court that morning, I noted a few things. He had requested continuances twice before finally appearing. He had no prior criminal record. His violations ranged from parking in no standing zones to blocking a fire hydrant, the kind of repeated careless pattern that doesn't suggest someone in desperate survival mode. It suggested someone in a comfortable routine who simply didn't prioritize the rules. I put the file down and waited for him to walk through my door. Let me walk you through the pattern that built these violations, because the story isn't in one single moment, it's in the accumulation. Over the course of 14 months, Daniel Mercer received 8 separate parking tickets in downtown Providence. Now, 1 parking ticket, that happens. 2, maybe you've had a rough stretch, but 8 tickets, all in the same general area of the city, all during weekday morning hours between 8 and 10 a.m., that tells me something very specific. That tells me this person has a regular routine, a regular destination, and a regular habit of ignoring the rules of that destination. 3 of the tickets were issued on the same block, a commercial district with clearly marked no parking zones during business hours. I know that area. Those signs are not subtle. They are large, they are bright, and they explicitly state the hours of restriction. When I first looked at this pattern, I thought, this person parks here every day for work. They know exactly what they're doing. They've made a calculation that occasional tickets are cheaper or more convenient than parking in a legitimate spot or a garage. It's a decision I've seen before, not malicious, not criminal, but deliberate. What I had not yet seen was how Daniel planned to explain all of this. When the court officer called his name and he walked up to my bench, I noticed immediately that he was dressed neatly. Pressed shirt, clean shoes, a folder of papers tucked under his arm. He'd prepared. And within the first few seconds of standing before me, before I'd even asked him a single question, he began his opening statement. He told me he'd been out of work for 7 months. He told me his wife had recently had surgery and that the medical bills had devastated their savings. He told me he had 2 young children at home and that he was barely keeping the lights on. He delivered this with exactly the right amount of weight in his voice. Not dramatic, not teary, just tired and earnest. I listened. I let him finish. I thanked him for sharing that with me. and then I started asking questions. As I continued reviewing the evidence and asking my questions, the story Daniel had prepared began to develop some very significant cracks. My first question was straightforward. I said, "Mr. Mercer, you mentioned you've been out of work for 7 months. Can you tell me what kind of work you do?" He told me he was in sales, corporate sales, and that his company had downsized and let him go. I nodded. "And these violations," I said, "they're all concentrated on Fulton Street weekday mornings. What were you doing in that area if you weren't working?" He hesitated, just briefly, just a flicker. But I caught it. He said he'd been going to interviews, that he had contacts in that area and was meeting with people regularly, trying to get back on his feet. I said, "That's admirable. How many interviews would you say you went to in that area over the 14 months these tickets were issued?" Another hesitation. "Several," he said. "I can't remember exactly how many." Now, here's what I'll tell you. When someone says, "I can't remember exactly," that can be completely honest. Memory is imperfect. I understand that. But the quality of that "I can't remember," the way it came out, the slight upward tilt of his chin, the way his eyes moved to the left, that told me a different story. I looked down at the file. The violations were consistent. Monthly, sometimes twice monthly, same block, same hours, for over a year. This wasn't someone going to sporadic interviews. This was someone with a routine. I said, "Mr. Mercer, I want to help you if you need help. That's genuinely what I'm here for, but I need to ask you something directly. Are you currently employed?" The room went quiet. He looked at me, and I looked back at him with the same calm, patient expression I've maintained for 4 decades on this bench. I wasn't aggressive. I wasn't accusing. I was simply asking. He said, "I'm in between things right now." I said, "That's not quite what I asked. Let me try again. Are you currently receiving any income from employment, freelance work, consulting, anything of that nature?" And that was the moment. He shifted his weight. He glanced at his folder, and then he said quietly, "I do some consulting work on the side, but it's not regular." I said, "I see. And that consulting work, does it take place in the Fulton Street area?" The pause that followed told me everything I needed to know. Now, by the time this case made its way to broader attention, the footage had been shared widely, and I was told that the clip of my questioning drew significant reaction online. People seemed surprised, and I think genuinely moved, to see the moment when the truth came to the surface. My clerk mentioned to me that comments were flooding in from people who had sat in situations like Daniel's, on both sides, people who had been struggling genuinely and felt the weight of every fine, and people who admitted, seeing Daniel squirm, that they'd tried something similar in their own lives. I want to be honest with you about how I feel about that kind of attention. On one hand, I'm grateful that people watch these proceedings and take something from them. If seeing how a courtroom works makes someone a better, more honest person, then the attention serves a purpose. But here's what I tell anyone who asks me about it. Whether one person is watching or 1 million people are watching, my job doesn't change. Not one bit. The camera doesn't make me tougher. It doesn't make me more lenient. It doesn't make me perform justice differently than I would on the quietest Tuesday morning when nobody's paying attention. Justice shouldn't be a performance. The moment a judge starts playing to an audience, the whole enterprise falls apart. I walk into that courtroom every single day, and I do the same thing. I listen, I question, I look at what the evidence shows, and I make the best decision I can with the tools I have. That's it. That's the job. When the full picture finally emerged in my courtroom, I want to tell you what happened, because this is the part that matters most. After Daniel's hesitation, I gave him a moment. I said gently, "Mr. Mercer, take your time. I'm not in a hurry, but I need you to be straightforward with me, because this process only works if we're honest with each other." He took a breath, and then, slowly, the truth came out. He was consulting for a company, the same company that had technically let him go, as an independent contractor. Same work, same clients, structured differently on paper. He went to their offices on Fulton Street several times a week, had been doing so for most of the period these violations were issued. The financial picture he had painted, the surgery, the savings depleted, the children, those details were real, he insisted, but the employment situation he had, as I said to him directly, shaded the truth. I looked at him for a long moment after he finished speaking. He was looking at the floor. I said, "Mr. Mercer, look at me, please." He raised his eyes. I said, "I appreciate that you just told me the truth. I want you to know that. It would have been easy to keep the story going, and you chose not to. That matters." I paused. "But I also need you to understand something. When you walked into this courtroom today, you came with a prepared narrative designed to make me feel sympathy for a situation that, while it has real elements of difficulty, was not the picture you were painting. You hoped that picture would make these fines disappear." He started to speak. I raised my hand gently. "Let me finish. I'm not angry with you. I want to be very clear about that. But here's what troubles me deeply. There are people who come into this courtroom, and I see them every week, who have genuine, devastating hardship. People who have to choose between a parking fine and medicine. People who have lost everything through no fault of their own. When someone uses hardship as a strategy rather than a reality, it does a disservice to every one of those people. It makes the judges and the courts that want to help them more cautious. Do you understand what I'm saying?" He nodded. His eyes were wet. I continued, "You made a choice every one of those 8 times to park in a prohibited zone. You made a calculation that it was easier, more convenient, and that if the fines ever caught up with you, you could handle them. And when they did catch up with you, you made another calculation, that a story of hardship would be more effective than accountability." I leaned forward slightly. "I've been doing this for 40 years, Mr. Mercer. I've heard every story there is to hear, and I'll tell you what I've learned. The truth always finds its way to the surface. Always. It might take questions, it might take patience, but it surfaces." Then I turned to the matter of what to do. I asked him directly, "What is your monthly consulting income, roughly?" He told me it was modest but not negligible, enough to live on, enough to address these fines over time. I asked about his wife's medical situation. He confirmed it was real. I acknowledged that. I told him I was sorry his family had faced that difficulty and that I meant it sincerely. I said, "Here's the difference between what you told me and what I needed to hear. I needed to hear, 'Judge, I have real expenses, my family has had real medical costs, but I am working and I can pay these over time if you'll give me a structure that I can work with. That's honest. That asks for fairness, not charity you haven't earned.'" He was quiet. "Instead, you came in here prepared to perform hardship, and that's what I can't let pass without addressing, not to punish you, but because you need to understand what you did. I've been on this bench long enough to know that the sentence is the last thing, not the only thing. What matters first is whether a person understands what brought them to this moment. The fine is almost secondary. The lesson is what I care about." I looked at Daniel Mercer and I said, "Mr. Mercer, here is what I'm going to do, and I want you to listen carefully to why I'm doing each part of it." I paused. "I am not dismissing these fines. You incurred them deliberately over an extended period, and the circumstances you described, while partially true, were deliberately framed to mislead this court. I won't reward that approach because doing so would be a disservice to you and to everyone else who comes through this door." Another pause. "However, I am also not going to impose the full amount as a lump sum. You have real family expenses. Your wife's recovery is real. Your children are real. So here is what I'm ordering. You will pay these fines in full, $640, in monthly installments of $80 over 8 months. That is manageable on your income. I'm not asking you to suffer. I'm asking you to be accountable." He nodded slowly. "Additionally, I am ordering you to complete 20 hours of community service at a location of your choosing, subject to court approval. Not because I want to add burden to your life, but because I want you to spend some time among people who are navigating real hardship. I think it will be valuable for you. I think it will give you perspective that will serve you for the rest of your life." I leaned forward one final time. "Mr. Mercer, you are clearly an intelligent man. You prepared for today. You organized your thoughts. You walked in here with confidence. I want you to use those qualities, your intelligence, your preparation, in service of honesty rather than maneuvering, because the world responds very differently to a person who says, Here is my real situation, please help me work through it, than to a person who constructs a narrative to extract a result. One builds trust, the other erodes it. I said, I hope you leave here today not embarrassed, but thoughtful. There's a difference. Embarrassment fades. Thoughtfulness changes you. After I adjourned, something happened that I think about still. Daniel didn't leave immediately. He stood at the edge of the courtroom while others filed out, and eventually he approached the bench. He asked if he could say something. I told him to go ahead. He said, I want to apologize, not for the parking tickets, for the other part. I told him I appreciated that. I meant it. I told him what I tell a lot of people in that moment, that the apology that matters isn't the one you offer the judge. It's the one you offer yourself. It's the moment of honesty when you're alone somewhere and you say, I did that and I'm going to do better. That's the apology that actually changes anything. He shook his head a little.